Legislative inquiries. The inquiry, to be within the jurisdiction of the legislative body to make, must be material or necessary to the exercise of a power vested in it by the Constitution, such as to legislate or to expel a member, and every question which the investigator is empowered to coerce a witness to answer must be material or pertinent to the subject of the inquiry of investigation. A question is material if it has a direct relation to the subject of the inquiry. So what is the scope of the power of legislative investigation? The power to conduct inquiry in aid of legislation in accordance with its duly published rules of procedure. The power to issue summons and notices in connection with matters subject of its investigation or inquiry. The power to punish or declare a person in contempt during or in the course of legislative investigation. Now, what are the limitations on the power of legislative investigation? These include that it must be in aid of legislation. It must be in accordance with the duly published rules of procedures, and the right of a person appearing in or affected by such inquiry shall be respected. Since Congress may only investigate into those areas in which it may potentially legislate or appropriate, it cannot inquire into matters which are within the exclusive province of one of the other branches of the government. Hence, in one case, the court held when issues sought to be probed by a House committee was already within the jurisdiction of the Sandigan Bayan, the former cannot inquire into the said issue without encroaching on the latter's judicial jurisdiction. Exemption from the coverage of legislative inquiry. When Congress exercises its power of inquiry, the only way for department heads to exempt themselves therefrom is by a valid claim of executive privilege. They are not exempt by the mere fact that they are department heads. The President is the only executive official exempted from the power of inquiry in deference to the principle of separation of powers. Now, any law which exempts any person from the power of the Congress to conduct legislative inquiry is unconstitutional. The Congress power of inquiry, being broad, encompasses everything that concerns the administration of existing laws as well as proposed or possibly needed statutes. It even extends to government agencies created by Congress and officers whose positions are within the power of Congress to regulate or even abolish. Publication of the rules. It is incumbent upon the House to publish the rules of its legislative inquiries in each Congress, or otherwise make the published rules clearly state that the same shall be effective in the subsequent Congresses or until they are amended or repealed to sufficiently put public on notice. However, only those that result in violation of the rights of witnesses should be considered null and void, considering that the rationale for the publication is to protect the rights of the witnesses as expressed in Section 21, Article 6 of the Constitution. Publication in the website or pamphlet is not sufficient.